We're going to wait for the last few people to get in through security, so. Mr. Balzer.
Thank you, Mr. Chairman. Over the lunch hour, we were able to research as best we could and determine that we are not aware of any confidentiality restriction in place that would prevent Mr. Addison from answering the question that Commissioner Elam asked.
Thank you. Go ahead and finish that one, and then, well, before we get started with any of these questions, Mr. Butler, you have an announcement.
Yes, Mr. Chairman. Thank you. I have a brief public service announcement. A very, very nice phone charger has been found in the back. I would say if any of you own it, please feel free to come up and see me. I've got it right here if you're missing a phone charger. Thank you.
Okay. Just a quick point here. We've been trying to encourage everybody to move along with this hearing, but it seems like sometimes when some of you get the mic, you sort of enter into your own space-time continuum, and I know, it's sort of like it's just you and your mic and your questions, and I know you're concentrating, and I know you've got a lot to do. I need for you to be more precise. I need for this to move along, because when you take so much time, it's just, I see it as a lack of respect for everybody's time in here, because we've got a very aggressive schedule to maintain, and we're not maintaining it right now. I understand the need to establish a record. I understand there are important things to ask. I understand that, there's some historical stuff that we need to know about, but, last night I went to a very highbrow classic concert, and the artists, the B-52s, they got every 40 years of work in about an hour and 15 minutes. This has only been going on for 10 years, so I think we can all shorten this stuff up, and we can get everything we need into the record. Okay, I've tried to remind gently, tried to be smiling, but I need for everybody to coordinate your cross exams. I need for you to be prepared with your exhibits. I need, if you're going to introduce an exhibit, you need to have copies already ready. We don't want to wait around with a lot of walking around. And I just want everybody to respect everybody's time in this room. We have an important task, but we got a finite amount of time. With that, Commissioner Whitfield is next on the agenda. And he has said, oh, no, let's finish Commissioner Elam's, and then Commissioner Whitfield has promised me he has one question.
Okay. Do I need to repeat the question?
You do not, Commissioner. Thank you. It was an informal oral proposal from NextEra.
Thank you.
You're welcome.
Commissioner Whitfield.
Thank you, Mr. Chairman. One subject, and I'll try to hold it to one question. It could be a follow-up depending on Mr. Addison's answer. Mr. Addison, your attorney stated in his opening that he characterized it, the blame for two reasons that why we're here. One, Westinghouse, the other, Santee Cooper. And under pretty good cross-examination, and I won't relive that, you backed off the Santee Cooper part, and you really just blame Westinghouse, you said here again on the stand. So since you're blaming Westinghouse, let's shift to Santee Cooper for just a minute. And it's been widely discussed here, and I won't relive that either, about Santee Cooper's generation needs or their lack thereof of their generation needs. And we're going way back years, 2012, that sort of thing. Would it not have, in your mind, as CFO at the time and now CEO, would it not have been prudent for SCE&G to know or have a better understanding of Santee Cooper's generation needs?
Yes, sir. I don't know that SC&G did not have an understanding of Santee Cooper's generation needs. I just don't know that personally. So I can't tell you that Mr. Byrne or Mr. Marsh or others in the organization did not have a good understanding of it. I just don't know the answer to that.
But if you're up on Wall Street raising capital and you didn't know a lot of this information that you're saying you didn't know about, or you didn't have firsthand knowledge of, for lack of a better word, and then you didn't know Santee Cooper's generation needs, wouldn't that have been a hard sell? Did those questions not come up on Wall Street? Can you enlighten me a little bit?
Yes, sir. Fair question. So there were a lot of questions from investors around Santee Cooper's continued commitment to the project when they were actively attempting to market part of their share. When we reached an arrangement between the two of us for the additional purchase that we discussed yesterday with
Yes, sir.
one of the interveners, and part of that arrangement was they would not seek to market more of that, then those questions subsided.
And nothing else further came up really about it, or
I don't recall
from the investment community?
That's correct. I don't recall any issue after that.
Well, that's all I have, Mr. Addison. Thank you, Mr. Chairman.
Thank you, Commissioner Whitfield. Commissioner Williams.
Thank you, Mr. Chairman. Good afternoon, Mr. Addison.
Good afternoon.
Now, if I understand correctly, you're from South Carolina, right?
I am.
Lancaster.
That's correct.
Lancaster, okay. And you went to the University of South Carolina for undergrad and graduate school?
I did.
And you started working for the company back in 1991, I believe?
Correct.
Okay. So it's fair to say that you're not tone deaf to the consternation, concern, and maybe even outright anger ratepayers have about this failed nuclear plant.
That's very fair.
You may be the CEO, but you're a member of this community, aren't you?
Absolutely.
And so, just so we're clear, and I want to give credit to all the lawyers here because all the lawyers here have done a good job. And you understand that some of your lawyers left their gloves at the door when this proceeding started. The gloves were taken off at the door, and there was some blame cast in the beginning of this hearing, right?
Yes, sir.
And I understand that you want to move past the blame, and I think we all do. But at the same time, there needs to be a certain level of accountability. Wouldn't you agree?
I agree.
And I think I understand your testimony to be that you're not blaming ORS for this failure, are you?
You're correct.
And you're not blaming the legislature.
Absolutely not.
You're definitely not blaming the ratepayers.
No, sir.
And I don't know if you said this or not, but I don't think you're blaming the PSC.
No, sir. I am not.
Okay. And you're blaming Westinghouse, definitely, right?
Yes, sir.
But I've never heard you come out and just say the level of accountability SCENG should have in this failure. What level of accountability should SCENG have in this failure?
Well, we definitely deserve accountability in this failure. There's no question about it. And as I described a couple of times, obviously, after we withdrew the abandonment application, we came out in mid-November with what I'll call a $1 billion accountability offer, and that was very poorly received, if received at all. Let's be straight about that. And then when Mr. Farrell and his team approached us a couple of weeks later and basically showed they could bring probably double the amount that we could and provide financial stability, that's my best answer, sir, is to bring that level of billions of dollars to the solution that otherwise we could not have.
All right, so it's fair to say that this failure is not an orphan. Wouldn't you agree?
We own it.
Okay, all right. Thank you, sir.
Yes, sir.
So considering that you own this failure, help me reconcile bonuses to anyone who worked on this new nuclear development project, considering the fact that it failed.
Yes, sir. I understand the frustration, and the board had to make those decisions based upon what was those goals were at the time and what was accomplished. And I don't know what else to say about that except that if Westinghouse, and I don't want to seem to be avoiding your question, I don't mean that at all, but if Westinghouse had not gone bankrupt, we would be moving forward with those projects, and the things that were accomplished under those goals would have been important along the way.
I don't disagree with that at all, but I just want to make sure that everyone who's watching this live stream and everyone that's here, and you're pretty popular, by the way. We've had the most views on the live stream since this thing started. So people are interested in what you have to say.
Yes, sir.
So is your testimony that ratepayers should not be responsible for any bonuses to anyone involved, anyone with SCE&G involved with this new nuclear development project, considering the fact that it failed?
Sir, I can't speak for Dominion, but I would offer to you that those aggregate bonuses are something that Dominion could probably consider in their solution, and make that a part of the amount that's written off to make that a non-issue. But they would obviously have to speak for that.
Okay. Now, is it fair to say that SCE&G made a business decision regarding to go with Westinghouse's projections in terms of production and costs? The production factor that they estimated or projected, the 1.15 that we heard so much about, is fair to say that SCE&G made a calculated business decision to move forward with those projections?
I think that's fair, sir. The company's position was that was the best information available at the time.
Okay. And that's I'm glad you said it that way, because you would agree it wasn't the only information that the company had at the time.
It absolutely was not. And as I said yesterday, with my 20/20 hindsight, I wish we had presented the other information and offered to run other scenarios at the time.
Right. And you were not CEO at that time, were you?
No, sir.
But you're the boss man now, right?
That's correct.
And so it's fair to say that if anything like that were to ever happen again, not that it will, it's fair to say that under your leadership, SCE&G would be fully transparent.
We will strive to be completely transparent. And not to run on with the answer, I'm aware of the chairman's admonishment, but I would say I want to go back to something Mr. James said. We have had an excellent relationship with ORS, and I think with the PSC. You can judge that for yourselves, your members that have been here for a while. We've got the same thing in the other two states we operate in. This is a very, very well-run company with a very, very difficult situation. And I believe if we can bring resolution to this, you will find that this is a company that's what it's always been, which is very transparent and will not be in that situation again. I'm very aware of the erosion of trust, as I said yesterday, and it will take time, a lot of time, to earn that back.
Now, a lot has been said about bankruptcy.
Yes, sir.
And I think that you would agree that everyone is concerned about South Carolina's energy future. Wouldn't you agree with that?
I would.
Okay. Especially the 800,000 or so customers that SCE&G currently has.
Yes, sir.
Now, ORS has presented a plan that provides according to them and according to my understanding, the deepest savings by way of a monthly bill, if you will, for customers.
There's no question in the short term that's the largest reduction.
It's the largest reduction. And I know there's some arguments that prudency or the lack thereof should go further back than March 12th, 2015. I understand that. But in terms of a actual proposed plan, ORS's plan has the lowest dollar amount per month for each ratepayer. Is that your understanding?
That's correct in the short run.
In the short run. Could you paint a picture for me, since you're the CEO, can you paint a picture for me of what the world would look like? What would this area, what would the 800 or so thousand customers that SCE&G currently has, what would their energy future look like under ORS's plan?
I don't think any of us know the answer to that. And you've heard from some experts, you're going to hear from more the next couple of weeks, and I don't think anybody can really project what would happen with absolute certainty. I I am quite sure in the long run, excuse me, the cost of capital to invest in this business will cost more under that plan than it would under one of the Dominion plans. And that inevitably has to get into the cost of service for customers. That's, I believe, very basic in the judicial background. So I don't think anyone really knows the answer to that. That's why all I can say is in the short run, it would be certainly less. The question is, what does it look like in the long run?
Do you think you could keep the company afloat under ORS's plan?
I don't know. And of course, that comes down to what does afloat mean. And I can't sit here today and tell you that the company would be in bankruptcy. I don't know that. I know it's been a very difficult 6 months. I'm sure Ms. Griffin will get into more of that, but it has been a very, very difficult 6 months, and that's only with the impact of this being temporary, the rate reduction, and it being largely offset from a cash standpoint by an 80% reduction in the dividend of the company. That's just not sustainable in the long run to attract $500 million of capital a year.
So your proposal, I'm going to ask you, if you had to vote on it, which plan would you vote for?
I think either one brings the customer stability, and I'm not trying to dodge your question. I think either one brings the customer stability in the long run and eliminates that issue because you've got a $45 billion market capitalization company behind you then, or close to $50 billion with the combined entities. So that issue is a non-issue. It really comes down to customer preference. If the feeling of the public policymakers, this body, the legislature, et cetera, is rate reduction's better than Plan B. If the feeling is let's get some cash in the economy and in customers' pockets and that washes out more of this bad taste than Plan A. And I think an important part of either of those plans are the stay out provisions. You know, a lot's been talked about our rates being higher than most in the region and maybe even in the nation. But I believe, and I'm going from memory here, that Dominion Plan B would result in our residential and commercial rates being, I believe it's about 3% higher than the Southeast average, lower than the national average, 3% higher than the Southeast average, and the industrial rates being more than 10% lower than the Southeast average. I think that's pretty staggering given you've got 2 abandoned nuclear plants and the addition of 540 megawatts of a gas-fired plant that's roughly equal to the new addition of 10% of our generation. So to have come through all this, clear the deck, know you got financial security, and being fairly close to the Southeast average is, I think it's a good outcome. So that's a lean towards Plan B, just from my perspective.
All right, thank you, sir. No further questions.
Thank you, sir.
Thank you, Commissioner Williams. Commissioner Urban.
Thank you, Mr. Chairman. Good afternoon, Mr. Addison.
Good afternoon.
Just looking at the September 2018 quarterly financials, your net income was up by $67 million.
Can I get to
Yes,
that?
sir. And while you're looking at $67 million, I believe, for net income on the positive side, which was almost 100% increase over last quarter. Net profit margin, 7.24%, the positive, which is, again, about 129% rounded over the prior quarter. Is that correct?
Let me make sure I'm with you. So that's
All right.
comparing the quarter ended this September to the one of a year ago?
I believe that's correct. Yes, sir.
Yes, sir. Yes, sir, that's correct, because in the quarter ended a year ago, there was an impairment loss of $200 million recorded related to these events.
And so I commend you on the job that you're doing to keep it afloat and keep it going. But and I realize that part of that's a write down.
Yes, sir.
But you took that in the third quarter
Of 17, yes, sir.
Yes, sir. Okay. Why did the board, or why did you, as an entity, wait so long to cut the dividend? Because as I recall, the dividend cut didn't come until what, July of this year? When was that?
That's correct, June or July.
Yes, sir. Why did they wait so long? Because that would have helped cash flow, would it not?
It would have, on one hand. On the other hand, it is it's an expectation, and utilities are known as income-oriented stocks. They pay dividends, yields of 4 or 5% or something of that nature. And the board knew, senior management knew, if there was a reduction like that, it was going to be have an impact on the cost of capital. And I think that experts later can talk about that. That's why I say it's not sustainable in the long run. But basically, it was done to largely offset the cash flow implications of the act passed by the legislature.
Historically, it's been relatively high in terms of percent.
The
Has it
payout,
not? Yes, sir.
payout ratio, yes, sir, has been our policy has been 55 to 60%, but that's actually lower than the utility industry, slightly lower than them, because we're in a big construction expansion.
Yes, sir. But there are other things that you could do as a standalone company to survive. You could sell off some assets.
We could.
You have a gas plant, I believe, in North Carolina that's valued at what?
Well, we had the discussion earlier about the entire business was an initial oral discussion of over $2 billion. That I think the challenge of that is this is an industry that's going through fairly rapid consolidation. I'd say it's condensed by a factor of half in the last decade, in ballpark. And investors, credit rating agencies view diversification of your territories as an important factor. And the more that you do, the less diversification you have, the more concentrated risk you have in one territory, even not just for catastrophic things like this situation, but even for normal things like just fluctuations in weather.
And if you were left as a standalone company, do you think that securitization would be an option that could greatly help SC or SCANA recover by restructuring its debt?
Yes, sir. I think Commissioner Hamilton maybe asked me about that earlier, and I'm not an expert in securitization. We'll have some that follow here that can address it in more depth, but all of our debt has make-whole provisions. Largely, if you pay that off, you've got to prepay the balance of the interest, and it's not a small prepayment. It's a significant. And the benefit of that is you get a much lower interest rate on the front end.
Right.
And so I'm not sure that there are huge benefits to it. There would certainly be some if you were securitizing the equity portion. I readily acknowledge that. The challenge I have with that is we as a state have been at this for a year and a half now, and that's going to add another probably year to legislation and affecting a transaction and things of that nature, and it's going to add even more time to not having a real complete answer.
Well, if the legislature was convinced that it would help ratepayers in terms of reducing their monthly residential utility bills, don't you think there would be a push to get it passed?
Sure there would.
The irrevocable trust to pay the the management team, I believe you said was funded by SCANA to the tune of $110 million.
Originally, yes, sir.
That was done about when?
Around the time that the transaction was announced, so 11 months ago, something like that.
Would you agree that it would only be fair to the ratepayers to exclude that $110 million that was used to fund executive bonuses and exclude it from the rate base so that it would not be passed along to the ratepayers?
Absolutely, and it never was intended to be. That essentially is as it relates to change of control. Now, some of that I said before was previously deferred compensation or things of that nature. So only about a third of it is related to these change of control agreements. And only those that lose their job would it apply to. But that would never be a cost associated with ratepayers, and essentially that would be borne by Dominion shareholders, current shareholders.
Thank you. And you would also agree with me that the $1 million that was paid for the Bechtel report by your attorneys in anticipation of litigation should also be excluded from any rate base since it was a legal expense?
I don't have an issue with that.
Why do you think the Construction Site Review Board only met 3 times during the course of the project after they were formed?
Commissioner, I believe that's just a matter of timing between the time they were formed and the time that Westinghouse announced their difficulties in bankruptcy, but I'm not positive of that. Mr. Young could confirm that when he's up later. Because
it would seem like there would be a sense of urgency at that point to get things back, get the project back on the schedule. I'm just wondering.
And let me just add, I believe, and Mr. Young can confirm this, I believe it was intended all along to be a quarterly process. I'm not positive about that. But
let's check on that and see if we can get some clarity on that.
We'll have him prepared to answer.
All right, sir. I'm wondering about the Toshiba parental guarantee. Was there any consideration or discussion about making it at a level that would also protect the ratepayers' interests? Because I know you really kind of protected your own interest as a company, but was there ever any thought to pushing that limit higher to protect the cost of the entire project with interest?
Yes, sir. The amendment to the contract in October of 15 was a comprehensive amendment of some 20-some different items, and jointly negotiated by the owners, SCANA and Santee, in a very short period of time of a few weeks. And I suspect that could have been a higher number, but other things would have had to give. It was a comprehensive negotiation that included, certainly that was a provision we hope would never play out. It included provisions of about $1 billion of liquidated damages and incentives to get them to hit their targets. And so it was a comprehensive list of issues, including resolving several $100 million of disputes that existed at the time, too. So it's a bit of a push and pull like any negotiation.
But toward the end, it concerned me to hear earlier that SC&G was essentially paying phantom invoices to Westinghouse just to keep the project alive during these negotiations. Is that? Can you tell me why that happened?
That's a poor choice of words, and I believe we own those words.
Yes, sir.
But Mr. Kokums can clear that up for you when he's up here later.
All right. Would you be sure he does that for us?
Absolutely.
That almost sounds like a poor business practice.
It is a very poor choice of words.
Yes, sir.
I don't think you'll feel that way once he explains.
Well, let's hope not. It could even rise to the level of fraud, or if it was truly a phantom invoice.
That's not the case, sir.
All right. You talked earlier about how the employees felt about, I'm talking about the line employees in terms of a merger. Is it fair really to say you can probably speak for the management team, but you can't really speak for all employees, can you?
I can't speak for all employees, but I can tell you that generally, and our management team has discussed this topic multiple times over the last now 11 months, and largely the operational employees that are across the 3 states. Look, Dominion's not going to send linemen down here from Virginia or gas journeymen from Ohio. Those folks' jobs are going to be right here. And you can, I would encourage you to, I'm sure you will, ask those questions to Mr. Farrell next week. Largely where any efficiencies are going to occur would be where these impacts are likely to happen, and that's why we've worked hard to hold and use contract resources where we could when some of those employees have departed in the past year, and not refill them with permanent employees so that we didn't impact them again.
And it's fair to say then that the real savings will likely come if the merger is approved. Ultimately, the management team is the one that's going to be on the line. They're the ones that probably going to lose their positions over time due to attrition or retirement or maybe even sooner.
I don't think there'll be many of those. Mr. Farrell will address that with you, but he's made comments very similar to that in front of our employees.
In terms of the comeback provision, and I think that is something that's important to look at. When you it's not the right phraseology, but
I'm not following you.
I believe the merger says you won't come back. Dominion won't come back. Stay out provision.
Yes, sir.
I think of it as comeback, but it's stay out.
Depends on your perspective.
Don't come back or do stay out. If you limit that, wouldn't it be better to limit it to more than 2 years? Since this is, you mentioned earlier in your testimony, it's going to take some time to make a transition, to merge the cultures, and to kind of get the IT on one system. Wouldn't it be better to wait more than 2 years to come back?
Was a great question, and that just guarantees a minimum. It doesn't mean that the company would be back in that time frame. I think the other side of that, the balance of that is, what if those merger savings have started showing up, and shouldn't the customer get a benefit of those? So it doesn't mean that SC&G will be in at the end of 2 years, but it just means that there's a prohibition up until that point in time.
Well, was there any thought to perhaps make it more appealing to ratepayers to extend that to more than 2 years?
That'd have to be something Dominion would have to answer. I can't answer that for them.
But in terms, you said that certainty is certainly one of the appeals for the merger, and that's true in a sense that you have financial certainty.
Yes, sir.
But it's also true that the management team that's guaranteed the bonuses in the event that you are leaving, that you have a certainty in terms of what your compensation would be. Isn't that true if in the event of a merger? In other words, don't you really have a vested interest in the merger yourself?
I do. I assure you under oath, my interest is in stabilizing this company. That's the commitment I made when I accepted the request almost a year ago now to take this responsibility. Those plans are in place, if you will, to make sure that if a merger or acquisition is discussed, is presented to management, that management doesn't take their own self-interest over those of the shareholders in making the decision whether or not to even entertain the offer. So that's what it's there for. I think Mr. Farrell can address this next week, but I don't expect many of those to be affected, and I think he will be glad to respond to that for you. I hope they're not, and I don't believe they will be.
Were there any bonuses paid after the March 12, 2015 filing to the management team?
Yes, sir. I'm sure there were.
Has anybody tried to separate out that figure, determine how much?
I can't separate it here today, but I believe it has been provided in response to ORS requests.
Why do you think that SC&G never had a fully loaded resource schedule for this project?
I don't know the answer to that, sir. If that's the case, I don't even know if that's absolutely the case. Mr. Young can reply to that.
Well, in the beginning, your own management team was concerned with what they call the generic schedule.
Yes, sir.
And that was recognized at the outset.
It was, as Mr. Elliott and I discussed this morning.
But never any progress was made toward trying to get a realistic schedule for completing the project?
No, there was substantial progress made, and the project was managed under a schedule. I think Mr. Young can give you much more detail on that. There was a schedule for the project all along the way.
It constantly changed, had to be updated and revised. And
It did, yes, sir.
those are all the questions I have. Thank you.
Thank you, Commissioner Urban. Commissioner Elam.
One question I overlooked, Mr. Chairman. Mr. Addison, on page 32 of your direct testimony, you state that SCANA and SC&G were not aware of the financial issues with Westinghouse prior to 2016. Is that correct?
I believe so. Which line are we?
8, 9.
Yes, sir.
As part of your contract with Westinghouse, did you have access to their financial statements?
No,
Why not?
because they're a privately held entity, and that was not part of the contract.
Is Westinghouse privately held, or is Toshiba?
Westinghouse. Toshiba is a public company, and that's their publicly traded stock is what's represented on page 34.
Okay. Thank you.
You're welcome.
Okay. Don't see any more lights on, so I won't even ask. Mr. Balzer, redirect.
We have no redirect, Mr. Commissioner.
Thank you. All right. Mr. Addison, you may step down.
May Mr. Addison be excused.
You may be excused.
Thank you, sir.
We're ready to call your next witness. Mr. Willoughby, whenever you are ready.
Good afternoon, Mr. Chairman, members of the Commission. We have a panel of Ms. Lapson and Mr. Hevert, and I'm going to ask Ms. Lapson first to summarize her testimony, and I'll get her testimony introduced into the evidence, and then I'll ask the same of Mr. Hevert. Ms. Lapson, would you please state your full name for the record?
Ellen Lapson.
And by whom are you employed and in what capacity?
I'm an employee of Lapson Advisory. I am the consultant on the financial affairs of utilities, and with a deep expertise in credit advisory and credit ratings and fixed income markets.
Ms. Lapson, in connection with this proceedings, and there are 3 proceedings, we've got a number of pieces of testimony I want to ask you about. In connection with docket number 217-370E, did you cause to be prepared and pre-filed on August the 2nd, 2008, direct testimony consisting of 44 pages?
2018.
Correct.
Yes, I did.
What year did I use?
2008. That was a hard year for me, too.
Well, it was a hard year for a lot of people. So maybe I haven't gotten over that. So in connection, are there any corrections or changes to be made to that testimony, Ms. Lapson?
No, sir.
If I asked you the questions that are presented therein, would your answers be the same?
Yes, indeed.
Mr. Chairman, I would move the introduction of her pre-filed direct testimony as if given orally from the stand.
Ms. Lapson's pre-filed direct testimony will be entered into the record as if given orally from the stand.
And Ms. Lapson, in regard to that direct testimony, did you have a total of 7 exhibits attached to it?
Yes, sir.
Are there any corrections or changes to the exhibits?
No, none.
Mr. Chairman, I would move as the next composite hearing exhibit the 7 exhibits attached to Ms. Lapson's direct testimony.
Ms. Lapson's exhibits attached to her direct testimony will be entered into the record as hearing exhibit number 72.
Ms. Lapson, next I direct your attention to docket numbers 2017-207E and 2017-305E. In connection with those proceedings on September the 24th of 2018, did you cause to be pre-filed the direct reply testimony of Ellen Lapson consisting of 12 pages?
Yes, sir.
Are there any corrections or changes to be made to that testimony?
No, sir.
If I asked you the questions contained therein, would your answers be the same today?
Yes, they would.
Mr. Chairman, we would move the direct reply testimony of Ms. Lapson in docket numbers 207 and 305 into the record as if given orally from the stand.
It will be entered into the record. Ms. Lapson's responsive direct will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. And Ms. Lapson, there were 3 exhibits attached to that responsive direct testimony. Are there any corrections or changes to be made to the exhibits?
No changes.
I would move the introduction as the next hearing exhibit, the 3 exhibits attached to Ms. Lapson's direct responsive testimony.
Okay, the exhibits attached to the direct responsive will be entered as hearing exhibit number 73.
Thank you, Mr. Chairman. And next, Ms. Lapson, did you cause to be prepared and pre-filed in docket number 2017-370E a rebuttal testimony consisting of 47 pages on October the 28th of 2018?
Yes, I did.
Are there any corrections or changes to be made? October 24 of 2018. Did I say a different date? Are there any corrections or changes to be made to the rebuttal testimony?
I have no changes.
If I asked you the questions contained in that rebuttal testimony, would your answers be the same today?
Yes.
Mr. Chairman, I would move into the record Ms. Lapson's rebuttal testimony consisting of 47 pages as if given orally from the stand.
Ms. Lapson's rebuttal testimony pre-filed will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. And Ms. Lapson, you had 6 exhibits attached to that rebuttal testimony. Do you have any corrections or changes to be made to those exhibits?
I have no changes.
Mr. Chairman, we would move the introduction into the record as the next hearing exhibit, the 6 exhibits attached to Ms. Lapson's rebuttal testimony.
Ms. Lapson's 6 exhibits attached to her rebuttal testimony will be entered into the record as hearing exhibit number 74.
Thank you, Mr. Chairman. And finally, Ms. Lapson, On October the 29th, did you cause to be prepared and pre-filed rebuttal testimony in docket numbers 2017-207E and 2017-305E consisting of one page?
Yes, I did.
And I might note, Mr. Chairman, that one page literally adopts the rebuttal testimony and puts it into those record. That record, Mr. Lapson, if I asked you those, are there any changes to that one page?
No, there are not.
If I asked you the questions that are contained therein, would your answers be the same here today?
Yes.
I'd move the introduction of the rebuttal testimony of Ms. Lapson into the record as if given orally from the stand.
Ms. Lapson's rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. And finally, Ms. Lapson, attached to that rebuttal testimony is one exhibit that consists of your 47 pages of rebuttal testimony, as well as the 6 exhibits that have already been introduced in docket number 370. Are there any changes to be made to that exhibit?
None.
Mr. Chairman, I would move into the record Exhibit 1 to the rebuttal testimony as the next hearing exhibit.
Be entered as hearing exhibit number 75.
Thank you, Mr. Chairman. And I would note for the record that Exhibit 75 includes the full rebuttal testimony as well as the 6 exhibits that are attached to the rebuttal testimony. So all of those were in the record in that docket. That was a long process, Ms. Lapson. Thank you for your patience. Have you prepared a summary of your testimony?
Yes, I have a summary.
And Mr. Chairman, I might indicate that we have 3 exhibits from her testimony that we're going to show during the course of her summary. That's part of her summary. With that, Ms. Lapson, are we all set? Ms. Lapson, are you prepared to deliver the summary?
Yes, I am.
Please do so at this time.
Thank you. Good morning, Chairman Randall and members of the Commission. I'm going to summarize 3 of those 4 exhibits that were just discussed. First, I'm going to discuss the Lapson direct testimony filed in Docket 2017-370E. In that direct testimony that I filed on August 2nd, 2018, I discuss the significant risk to customers resulting from the weakened financial condition of SCE&G and SCANA absent the proposed business combination between SCANA and Dominion Energy. The plans proposed by other parties in this case would result in severe and adverse financial consequences. The customers of SCE&G need a financially sound utility in order to preserve and enhance the quality and reliability of electric service and to satisfy future growth needs of the service territory. The business combination as proposed by the joint applicants, including the related conditions, represents the most favorable of all the alternatives and the one alternative that best balances the long-term interests of SCE&G customers with the need for a stable and financially sound utility company. As shown in Tables 1 and 2 of my direct testimony filed on September 24th, 2018, in docket number 2017-207E and 2017-305E, in January, at the beginning of this sequence, in January of 2017, SCE&G had credit ratings of BBB, BBB+, and Baa2 from Fitch, S&P, and Moody's, respectively. SCANA had credit ratings of BBB-, BBB+, and Baa3 from those 3 agencies. Each of these credit ratings reflected that the companies were judged to be investment grade. Now, I know that those ratings, may be confusing letters and numerals. So exhibit number 2 shows, if you could make those bigger, Lauralee, thank you, shows what the credit ratings are. On the left-hand side, you see Moody's credit rating scale, and on the right-hand side, you see the equivalent ratings of Fitch and Standard & Poor's, who use the similar characters. And they're at BAA1, BAA2, BAA3, you have the equivalent of Standard & Poor's BBB ratings. Those are the bottom level of the investment grade category. Below that, you see the non-investment grade ratings or speculative gradings, BAA1 and BB plus. So those are equivalent ratings, BAA1 and BB plus. And I call this region the slippery slope. So as this exhibit to my direct testimony shows, companies that are rated BAA3 and higher by Moody's and rated BBB minus and higher by S&P and Fitch are considered investment grade. Companies that are rated BA1 and lower by Moody's and BB plus and lower by S&P and Fitch are considered not investment grade or of speculative grade quality. As going back to our picture of the ratings today, SCE and G is currently rated by Moody's at BAA3 and by S&P at BBB minus, which ratings are one notch above speculative grade. And that shows you the current ratings today for SCE and G. Fitch currently rates SCE and G at BB plus, which is below investment grade in the speculative grade category. As the credit rating agencies have clearly informed the investing community, they are carefully watching this proceeding, and the Commission's decision in these dockets will precipitate a careful review of SCE and G's credit metrics. Any write-down of the BLRA regulatory asset in whole or in part results in the balance sheet value of common equity being written down as well. For example, the ORS plan would result in an incremental write-down of approximately $1.4 billion. Since SCE and G's debt will remain an obligation that must be paid even if the regulatory asset account is reduced, SCE and G's debt leverage measured in relation to equity or in relation to the expected future cash flow would worsen. If total debt to capital exceeds 60%, as would be the case under the ORS plan, SCE and G's finances would be deemed to be highly leveraged, impairing SCE and G's financial flexibility and resulting in speculative grade ratings by all three credit rating agencies. This would be a very slippery slope and places the company in a most precarious and vulnerable financial position. In such a weakened financial condition, any additional stress, such as an economic downturn, major storm event, a loss of customers, or other need requiring immediate financing, could cause SCE and G's debt to rise and to rise to or to exceed 70% of capital, which would result in a default of its financial covenants on its revolving credit facilities. The utility in such a weak financial condition will have difficulty fulfilling its obligation to meet the needs of electricity consumers. SCE and G is obligated to invest continuously in long-lived fixed assets, such as grid modernization for renewable energy resources, advanced metering, and system integrity. These types of programs require steady access to bank credit facilities and to the bond market. When a utility has insufficient cash flow and poor access to new capital, however, it may not have the financial resources to invest in expanding its system to serve new customers or to maintain and improve the quality and reliability of its power supply and delivery. In my experience, utilities in financial distress often suffer degraded reliability do not have the resources to foster industrial development and job creation in their service territory, and cannot carry out preventive maintenance, retain full crew strength for tree trimming, also known as vegetation management, or maintain ample inventories of spare parts. Such utilities become more vulnerable to windstorms, other hazards, natural disasters, and thus cause the economy of the utility service territory to suffer. The Commission has a clear choice in these dockets that will prevent the substantial risks associated with a financially weakened or distressed utility. In my opinion, SCE&G's customers will benefit from the joint applicant's customer benefit plan or the alternate customer benefit plan submitted by Dominion Energy. The benefits will result from a combination of lower customer rates and Dominion Energy's size and financial strength as the new ultimate parent of SCE&G. Maintaining the experimental rate or adopting the more draconian ORS plan would undermine SCE&G's financial condition, resulting in reduced operating cash flow, a severe asset write-down, and a serious reduction of common equity. This would undermine SCE&G's ability to satisfy the needs of its customers for safe and reliable utility services, and would not be beneficial to the interests of customers in the long run. Secondly, I will summarize my direct testimony filed in dockets number 2017-207E and 2017-305E. This followed my direct testimony filed on August 2nd, 2018, and after that point, significant credit events resulted from the passage of Act 258 and the imposition of the experimental rate, which reduced retail electric revenues by approximately 14.8%. As discussed in my direct testimony filed on September 24, 2018, the credit markets promptly reacted to these events. As shown in the tables to this testimony, on August 8, 2018, as a direct result of the federal court's refusal to stay the imposition of the experimental rate, Fitch downgraded the long-term credit rating of SCE&G from BBB- to BB+, a speculative grade credit rating, and of SCANA from BB+ to BB, also in the speculative grade. The next day, on August 9, 2018, S&P also announced a credit downgrade of SCANA and SCE&G from BBB to BBB-. That leaves us with the current situation in which SCE&G's current credit ratings are in the bottom 3% of the credit ratings of all U.S. rate-regulated, investor-owned electric and gas utilities. In fact, SCE&G is the single lowest rated of 111 utilities rated by Moody's due to its negative credit outlook and Rating Watch negative status. As shown in Table 2 to my rebuttal testimony filed on October 24, 2018 in docket number 2017-370E, the current ratings are almost certain to be further lowered if the ORS plan is approved. When Fitch downgraded SCE&G following the 14.8% electric rate cut imposed by the Commission pursuant to Act 258, Fitch explained that it would likely downgrade SCE&G's and SCANA's credit ratings even further if the merger fails to close. If liquidity is constrained, if the terms of cost recovery for stranded assets are unfavorable, or if the regulatory and legislative environment in South Carolina continues to be non-constructive, or if credit rating metrics deteriorate. So any of those factors could trigger a downgrade. S&P, in its decision, stated that the downgrade on SCANA and its subsidiaries reflects its expectation of reduced consolidated credit metrics over the next 2 years, even after incorporating the company's announced cut to its dividend payments. S&P maintains the ratings of SCE&G and SCANA on CreditWatch negative pending the outcome of these proceedings. Finally, I will summarize my rebuttal testimony. In my rebuttal testimony, I state that the recommendations of witnesses Baudino, Colin, O'Donnell, and Rubin, if adopted by the Commission, would severely reduce SCE&G's ongoing cash flow and would place the company in a weakened financial condition, a distressed situation. In sum, the ORS plan and proposals by Rubin and O'Donnell are likely to drive SCE&G's issuer credit into the sub-investment grade or speculative grade category, with attendant risk of losing access to capital during cyclical periods of constrained financial markets. By comparison, the customer benefit plan or alternate plan and the proposed Dominion Energy business combination provide a clear path to restoring SCE&G's creditworthiness within the investment grade category while also providing benefits to current and future customers. The opposing witnesses failed to give appropriate consideration to the necessity for a utility to have sound and stable financial condition in order to provide reliable service to customers, to withstand emergencies such as severe storms and economic downturns. Mr. Baudino makes faulty and misleading comparisons regarding the company's offering of first mortgage bonds in August 2018 when compared to other issuances of 10-year mortgage bonds. SCE&G had to pay 66 to 70 basis points more than the average utility, reflecting that the investment community requires higher compensation to accept the greater risk that they perceive in the company. Mr. Colin's recommendation that SCE&G defer a rate of return while immediately flowing through all the benefits of the TCJA will result in severe regulatory lag is unjust and will further weaken cash flows that would already be greatly weakened by the other aspects of the ORS plan. As shown in Table 2, we're going to go back to Table 2 of my rebuttal testimony in docket number 2017-370E. Adoption of the ORS plan would likely result in S&P lowering SCE&G's credit rating to BB+, or possibly BB. That is shown in the third row. S&P's ratings currently on CreditWatch negative would likely be reduced to BB+ or BB. Moody's would likely lower its credit rating to Ba1 and Fitch to BB. These are the SCE&G predicted ratings that I've produced. By comparison, approval of the business combination plan and customer benefit plan proposed by the joint applicants likely would result in S&P credit ratings of at least BBB, Moody's of at least Baa3, and Fitch of BBB-, and stabilization of the ratings by all of the agencies. So the alternatives are sub-investment grade or investment grade ratings. And I think that is a significant difference in the eyes of the financial community and bond market. Mr. O'Donnell suggests the measures that would not remedy SCE&G's ongoing credit problem of weak operating cash flow resulting from the implementation of the ORS plan and underestimates the incremental cost of a credit downgrade. In sum, Mr. O'Donnell seeks to minimize the costs and impacts that will result from weakening SCE&G's financial condition, but his analysis understates the real costs and effects. Mr. Rubin's recommendation that there should be no further recovery of NND project costs is a radical and extremely punitive suggestion and it would have disastrous impact on SCE&G's ability to sustain itself, to be viable, and to meet customers' needs for high quality of utility service, consequences that Mr. Rubin fails to consider. The ORS proposes a securitization transaction that is a red herring. Such a measure cannot be acted upon by the Commission at the present time, as the Commission is well aware, because the legal framework does not exist to permit the supposed securitization transaction, and there are legal hurdles and other issues that need to be cleared away before any such transaction would become feasible. In my experience, securitization also has some potential negatives that the Commission should consider at the appropriate time when a transaction is before the Commission. First, a securitization of the regulatory asset would exacerbate the condition of weak operating cash flows in the event of the implementation of all the other parts of the ORS plan. Second, the new securitization debt would appear on the balance sheet of SCE&G and would remain in place for many years or decades without corresponding equity to balance the capital structure. Third, a securitization transaction is an extremely inflexible financial structure, and it would eliminate some future options both for policymakers, the legislature and the Commission, and for SCE&G's customers. It also is not clear that there is an assured investment market for the estimated $2.67 billion of bond issuance that the ORS proposes in such a transaction. Debt market participants may not give credence to the willingness and ability of South Carolina public officials to stick with the terms of the securitization if economic conditions change, given that the legislature retroactively changed the BLRA after the company and investors had relied upon it to fund the construction of the nuclear plant. Also, if the regulatory asset to be securitized is created amidst ongoing litigation, that uncertainty could limit investors' interest in funding the transaction. This concludes the summary of my testimony.
Thank you very much, Ms. Lapson. And I will ask you to be patient with us for just a moment, and the Commission as well, as I now turn to Mr. Havert. Mr. Havert, would you state your full name for the record, please?
My name is Robert Havert. Last name is spelled H-E-V as in Victor, E-R-T.
And by whom are you employed and in what capacity?
I am a partner with Scott Madden Incorporated of Westborough, Massachusetts.
And in connection with this proceeding, Mr. Havert, did you cause to be prepared direct testimony consisting of 78 pages in docket number 2017-370 and filed with the Commission on August the 2nd of 2018?
Yes, I did.
Are there any corrections or changes to be made to that testimony?
I have one change, and I apologize for this. It's a small one.
Would you direct our attention to the line and page?
Yes, it is on page 70, line 15. There's at line 15, there should be a clause after the parenthetical, and that clause should read, it ranged from 9.5% to 10.55%.
Just for clarity, would you state that one more time? It ranged from?
It ranged from 9.5% to 10.55%.
Are there any other changes or corrections to be made to the testimony?
No, there are not.
Would that change, Mr. Havert, if I asked you the questions that appear therein, would your answers be as given?
Yes, they would.
Mr. Chairman, I would move into the record of docket number 2017-370, the direct testimony of Mr. Havert of 78 pages as if given orally from the stand.
Mr. Havert's pre-filed direct testimony in 2017-370 will be entered into the record as though given orally from the stand.
And Mr. Hebbert, attached to that pre-filed testimony was your resume listed as Attachment A and 6 exhibits. Is that correct?
That is correct.
Mr. Chairman, we would move the resume and the 6 exhibits into the record as the next composite hearing exhibit.
They will be entered into the record as hearing exhibit number 76.
I failed to ask this, Mr. Hebbert. Were there any changes to any of those exhibits?
No, they were not.
Next, I would draw your attention, Mr. Hebbert, to docket numbers 207 and 305 and ask you if you filed direct responsive testimony consisting of 9 pages on or about September the 24th of 2018 in those 2 dockets.
Yes, I did.
Are there any corrections or changes to be made to that testimony?
No, there are not.
If I asked you the questions that are written therein, would your answers be the same?
Yes, they would.
Mr. Chairman, we would move into the record of docket 207 and 305 of the 9 pages of Mr. Hebert's responsive direct testimony as if given orally from the stand.
Mr. Hebert's pre-file responsive direct testimony in 2017-207 and 305 will be read into the record as if given orally from the stand.
Thank you very much, Mr. Chairman. And attached to that testimony, Mr. Hebert, were 2 exhibits. Are there any changes or corrections to those exhibits?
No, there are not.
I would move into the record, Mr. Chairman, as the next hearing exhibit, the 2 exhibits of Mr. Hebert's attached to his responsive direct testimony.
They will be entered as exhibit number 77.
Thank you, Mr. Chairman. Next, Mr. Hebert, I would direct your attention to docket number 2017-370E and asked if you caused to be prepared and pre-filed rebuttal testimony in that docket consisting of 64 pages.
Yes, I did.
Are there any corrections or changes to be made to that rebuttal testimony?
2 minor changes.
Would you direct our attention to the page and line number, please?
Yes. Excuse me. The first is on page 4, line 13. At the very right-hand margin, there is a number 7.39. That should be 7.66.
And the next change?
Next change is on page 62, line 9, right toward the middle of the line, and it's the same change. 7.39 should be 7.66.
Are there any other changes to be made?
No, there are not.
If I asked you, with those changes noted, Mr. Hebert, if I asked you the questions that appear in the pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, I move into the record with the changes that have been noted, the rebuttal testimony of Mr. Hebert consisting of 64 pages.
Mr. Hebert's pre-file rebuttal testimony with changes will be entered into the record as though given orally from the stand.
Mr. Hebert, did you have a total of 13 exhibits attached to the rebuttal testimony?
Yes, I did.
Are there any changes or corrections to be made to those exhibits?
No, there are not.
Mr. Chairman, I would move into the record of docket number 2017-370E, Mr. Hebert's 13 exhibits as the next hearing exhibit.
Mr. Hebert's 13 rebuttal exhibits will be entered into the record as exhibit number 78.
Thank you, Mr. Chairman. And finally, Mr. Hebert, I direct your attention to dockets 2017-207E and 2017-305E and asked if you caused to be prepared and pre-filed rebuttal testimony in those dockets consisting of 2 pages on October the 29th of 2018.
Yes, I did.
Are there any changes to be made to the rebuttal testimony?
No, there are not.
If I asked you the questions that appear therein, would your answers be the same?
Yes, they would.
Mr. Chairman, I move into the record as if given orally from the stand, Mr. Hebert's 2 pages of rebuttal testimony in docket numbers 207 and 305.
Mr. Hevert's pre-filed surrebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Chairman, for the record, and Mr. Hevert, attached to that surrebuttal testimony was one exhibit which included all of your testimony, rebuttal testimony from Docket 370, including your 13 exhibits. Is that correct?
That is correct.
And, Your Honor, we would note that the same corrections that were made to the rebuttal testimony should be reflected in these exhibits as well, but we would move this one exhibit into the record as the next hearing exhibit.
It will be entered into the record as hearing exhibit number 79.
Thank you very much, Mr. Chairman. I appreciate your patience. A lot of dockets, and we've got to get them into the record. Mr. Hevert, have you prepared a summary of your direct testimony, rebuttal testimony, and your the points in your testimony in these cases?
I have.
Please deliver that at this time.
Thank you. Chairman Randall, members of the Commission, the purpose of my direct testimony is to estimate the company's cost of equity, sometimes referred to in regulatory proceedings as the return on equity, or ROE. Based on the information and analyses discussed throughout my direct testimony, I conclude that the company's cost of equity falls in the range of 10.25% to 11%, and that a reasonable point estimate is 10.75%. The cost of equity is the return investors require on equity investments of comparable risk. Like the interest paid on debt, the cost of equity is a cost set by investors in competitive capital markets. Unlike the cost of debt, which can be observed in the interest rates required by investors, the cost of equity is neither directly observable nor contractually defined. Estimating the cost of equity, therefore, requires the careful application of various financial models to observable market data and reasoned judgment in interpreting their results. It is an empirical but not an entirely mathematical exercise. My direct testimony explains that all models used to estimate the cost of equity are subject to their own sets of assumptions and constraints. I discuss broad market considerations, including the effect of federal intervention in the capital markets, recently increasing interest rates, and the effect of the Tax Cut and Jobs Act, and explain the challenges created by those factors in applying the models and interpreting their results. I note that as market conditions change, each model's ability to reasonably estimate the cost of equity also changes. That is, a model that may have produced reasonable and reliable ROE estimates under one set of market conditions may produce estimates that are less reasonable and less reliable under a different set of conditions. It therefore is important to understand each model's fundamental assumptions and to assess the extent to which those assumptions align with prevailing and expected capital market conditions. With those considerations in mind, I applied three widely used methods to estimate the company's cost of equity. In my experience, the use of multiple methods is consistent with regulatory practice, but equally important, it is consistent with investor practice. That practice makes sense simply because the cost of equity is inferred from stock prices, which are set by the buying and selling behavior of individual investors. No single model reasonably can capture the factors motivating those decisions for all investors at all times. Based on those analyses, which necessarily produce a range of results, I conclude that the cost of equity for SC&G currently is 10.75%. My direct testimony also considered the pro forma effect of 4 separate rate scenarios for the company's earned return on common equity. Those scenarios, which are based on analyses contained in Ms. Griffin's direct testimony, indicate that the experimental rate, if made permanent, would result in a pro forma return of 6.67%. I explained that in my experience, no regulatory commission has authorized a return on equity as low as 6.67%. I note that when a utility's financial profile is compromised, as it would be with the return on equity as low as 6.67%, the return investors require to accept that additional risk would increase. Because there is not a single publicly traded utility in the U.S. with a similarly compromised financial profile, we cannot draw from current utility market prices to estimate that additional required return. Therefore, we must use a reasonable proxy to estimate the likely increase in SCE&G's cost of equity. Looking to estimated credit spreads for below investment grade utility debt and difference in beta coefficients, which are a measure of market risk, between financially sound utilities and less sound companies operating in energy and natural gas sectors, I estimate that the additional return required if the experimental rate is made permanent to be in the range of 220 to 625% basis points, 2.2% to 6.25%. It is important to note that my 10.75% cost of equity recommendation does not reflect that additional investor required return. Rather, I provide those estimates for the Commission's consideration with the knowledge that if the experimental rates are made permanent, the company's cost of equity likely will increase. My rebuttal testimony responds to Mr. Baldino's direct testimony as it relates to the company's cost of equity. I focus on Mr. Baldino's 9.1% ROE recommendation, which falls well below the returns authorized for other utilities. Because the company must compete for capital, Mr. Baldino's recommendation would compromise SCE&G's ability to acquire the capital needed to fund utility operations and to do so at reasonable costs and terms. Putting aside our disagreements regarding methodological issues, Mr. Baldino has not explained why investors would provide capital in anticipation of a 9.1% return when higher returns are available by investing in other utilities. In short, I find Mr. Baldino's ROE recommendation to be unduly low and see nothing in his testimony that would cause me to alter my recommended range or point estimates. Regarding methodological issues, I disagree with many of the assumptions underlying Mr. Baldino's analyses and discuss those points in detail throughout my rebuttal testimony. My principal disagreement with Mr. Baldino lies in his substantial reliance on a single method, the constant growth discounted cash flow model, to estimate the cost of equity. Such a limited approach is inconsistent with long-standing and well-recognized principles of finance. In addition, Mr. Baldino fails to estimate the additional return required if the ORS plan were to be adopted. My rebuttal testimony also responds to Mr. Baldino's criticisms of my analyses and of the conclusions I draw from them. I explain why Mr. Baldino's understanding of the empirical capital asset model is misplaced and why, contrary to his assertions, that method is a reasonable and proper approach. I also explain why Mr. Baldino's criticisms of the bond yield plus risk premium method are unfounded and discuss the important financial relationships that method captures. My rebuttal testimony further discusses Mr. Baldino's observations regarding changes in utility bond yields and stock indices and why those observations do not support his 9.1% ROE recommendation. I further note that although Mr. Baldino suggests his recommendation is reasonable in light of historical earned returns, it falls far below the forward-looking returns provided by Value Line, a principal source of data underlying Mr. Baldino's discounted cash flow analyses. Consistent with my recommendation, those forward-looking returns fall in the range of 10.3% to 10.5%. Lastly, my rebuttal testimony updates the estimates of the additional return likely required by equity investors if the ORS plan is adopted. If the ORS plan is adopted, the investment community would perceive greater risk and the upper end of the range will increase. My rebuttal testimony estimates that range to be from 220 basis points to 650 basis points. Thank you, and that concludes my summary.
Thank you very much, Mr. Chairman. When I was cross-examining Mr. Baldino, there was one exhibit that I had tendered, and Mr. Nelson had objected to it. It's Exhibit 40. And the objection, I think, went to authenticity. I was going to ask this is an exhibit that Mr. Havert is familiar with, and he's used it in one of his exhibits, and I was going to ask him to authenticate it if the objection still stands.
Mr. Chairman, if you might allow me to introduce
Yes,
my law partner, Eric Amstutz. These are his witnesses, and so I would ask him to address that issue.
We object to the introduction of this exhibit. We understand that SCE&G objected in the context of Lane Colin's testimony to our trying to go beyond the pre-filed testimony. This was not in any pre-filed testimony from SCE&G. and doesn't say where it comes from and contains no other sort of indications of reliability.
And there's no question, this exhibit, Exhibit 40, was not an exhibit to his testimony. It's part of the working papers that he used in developing his opinions and the exhibits that he has in this case. But I thought the objection, when I attempted to introduce it with Mr. Baldino, was to the authenticity of the document. All I was going to do is get Mr. Hevert to authenticate the document, its source, its reliability. It's the type of documents that experts routinely rely upon, and it's used in developing opinions that everyone in this industry is accustomed to using.
Our objection is to both admissibility and authenticity.
Hey, Mr. Willoughby, if you can ask Mr. Hevert, excuse me, getting different words in my ears, about the authenticity.
Very quickly, Mr. Hevert, let me hand you a copy of this document. Mr. Hevert, I would represent to you that document has been marked for identification as Exhibit 40. Is that a document with which you are familiar?
It is, and in fact, this is the same information that I relied on in my direct testimony. Table 11, page 70, I believe footnote 75, Sources Regulatory Research Associates, which is the organization that produces this exhibit. So yes, it's a source with which I'm familiar. It's a source on which I relied in producing my direct testimony.
Is it for experts in your field of study and expertise, Mr. Hevert? Is it a source of information that is generally relied upon by experts in your field?
I've seen it relied upon in many cases, yes.
And have you relied upon it in many cases?
I have indeed, including this case.
And do you find it to be a reliable source of information?
I do.
And do you find it to be a source of information that experts use to try to measure credit issues and the constructive nature of regulatory environments in various states?
Yes, I do.
Thank you very much. I would move its introduction, Mr. Chairman.
We object. We continue to object. Just because it's admissible doesn't make it reliable. I'm sorry. Just because he relied on it doesn't make it admissible.
We're going to let it in as exhibit number 40.
Thank you very much, Mr. Chairman. And I would note, Mr. Chairman, that, and I don't say this to limit anyone's cross-examination, Ms. Lapson is available to be with us for the remainder of this afternoon, but is not available any of next week. She has longstanding commitments. And we really very much appreciate the Commission making a day certain available for her. Mr. Hevert has more flexibility. If the cross-examination of Ms. Lapson is not complete today, then she would not be able to return until the 19th. Mr. Hevert, again, has flexibility, but I would probably ask that if the cross-examination does not finish today, that we look at bringing them back on the 19th. But I am very hopeful that all of the questions can be finished today, if at all possible.
Okay, we'll try to push through on that. So are we ready? Ready for cross? Mr. Guile.
I have no questions. I'm going to help out my friend, Mr. Willoughby, there, Mr. Chairman.
Thank you, Mr. Guile. Other parties, yes.
Could I get the Elmo, please? Mr. Hevert, Ms. Lapson, how are you? My name is Will Cleveland. I'm an attorney with the Southern Environmental Law Center. representing the Coastal Conservation League and the Southern Alliance for Clean Energy. Mr. Hebert, I apologize. I don't actually have any questions for you, so you're just going to have to sit there. I hope you're okay with that.
It's one of the things I do best.
I'll wait for the overhead projector to come up. Ms. Lapson, this is the copy of your summary that you read today. Is that correct?
Make sure that read.
Yes,
yeah,
it is.
there you go.
Yes.
For the record, this is page 3. My first question is on line 14, you mentioned the alternate customer benefit plan. By that, do you mean what some people have been calling Dominion 2.0 or the second Dominion offer?
I've heard it referred to as Plan B.
Okay.
Plan A and Plan B.
Am I correct that nothing in either of your direct testimonies or your rebuttal testimony actually analyzes Plan B in any way?
I didn't receive Plan B until quite recently, but I did analyze Plan B after the fact, and I wish to say that I view either Plan A or Plan B as being desirable options because both of those were put forth by Dominion as plans that would cause them to go ahead with the merger transaction. And I find there to be substantial benefits in the merger transaction, and my analysis of the cash flow implications of Plan A or Plan B combined with the very great credit benefits of the merger with Dominion to be highly desirable to preserving investment grade status for SC, E, and G to the benefit of all stakeholders.
Thank you. Have you provided any of your analysis of that cash flow of Plan B to the Commissioner or to any other party?
No, I have not.
Thank you. This is page 2, line 22. Your SCE and G. SCE and G is obligated to invest continuously in long-lived fixed assets such as grid modernization for renewable energy resources, advanced metering, and system integrity. When you say they are obligated to continuously invest in these long-lived assets, is that a statutory obligation that they have to do grid modernization?
No, there is no statutory obligation. If the Commission, however, finds that to be desirable, then the Commission would indicate it to the company. But they have to meet demands of customers, so they are continually required to meet customer demands. Customer demands, as the Commission is well aware, and the Commissioners certainly know this, customers' demands for reliability of service are continually rising. Customers need extensions of service to areas not previously served, but they also want to have continuous service. They want to have reliable service that doesn't go out every time there's a storm, that doesn't flicker. They don't want their computers to go down. They don't want their refrigerators to stop working. Industrial customers don't want to have interruptions of their power. So as the needs of customers develop over time, and evolve, we are a more and more highly electrified economy, and customers have those needs. And furthermore, gas customers also have needs that need to be met for the modernization of gas networks, for gas infrastructure, and to protect the public interest in that direction also. So there is a continuous need for all sorts of types of investment, and I've heard that mentioned by commissioners this morning who spoke from en banc.
Okay, thank you. And I don't disagree that customers demand reliable electricity service. And in the interest of time, I'm going to ask you just a bunch of yes or no questions so we can move this along because I know a lot of parties have questions for you. In your testimony on pages 30 and 39, you discussed the different...
I'm sorry, I have different testimonies.
Okay, fair enough.
Tell me which one.
This is in Docket 2017-370E. And all I'm asking is that in that testimony, you discussed the different customer benefits plan, the customer benefits plan, the no merger plan, and the base request. Is that correct?
On page?
Page 30 for the customer benefits plan.
I'm sorry.
Like I can put it on the Elmo.
Dockets 207E and 305E?
370E.
$370, yes.
Okay.
Page 30. Yes, I'm there.
Great. This is Exhibit 13, companies.
I believe I have.
And is it your understanding that all three of the joint applicants' proposals for cost recovery of the new nuclear development project begin with this schedule of the calculation of the costs, the capital costs?
I cannot verify that. I'm not sure.
So you're not aware of how much the company is claiming has incurred and is legally entitled to recover for capital costs?
You asked a different question. You asked whether all of the plans start from the same basis. Which were all of the plans? Could you restate the question?
Sure, I'd be happy to. And to the extent it was not clear, I apologize. The customer benefits plan, the no merger plan, and the base request, the three different company plans.
The company plans. I presume that all of the company plans start from the same data.
Okay. Thank you. And is it your understanding that that starting point is Exhibit 13, which is on the screen?
That may be the case. I am not sure of it.
Okay. And is it your understanding of the different plans that they have a same starting point and then offer differing discounts, write-offs, rate rebates to achieve different levels of savings for customers?
That is probably accurate.
Okay. And on page 44, that same direct testimony I was pointing to you, 370E.
Make sure when you're in front of the mic when you talk.
Yes, Mr. Chairman, I apologize. This is page 44 of that same direct testimony, lines 13 through 16. You state that the business combination as proposed by the joint applicants, including the related conditions, represents the most favorable of all alternatives and the one alternative that best balances the long-term interests of SCE&G customers with the need for a stable and financially sound utility company. Is that correct?
Yes.
And you still believe that?
Yes, I do.
Okay. I'd like to talk about customers' best interests, if I could. Your various testimonies in the summary you just read today also discusses the ORS optimal plan. Is that correct?
Yes, it does.
And you reviewed that plan, did you not?
I did, sir.
Okay. And the ORS optimal plan has a different calculation for what the recoverable NND costs are than any SCE&G plan. Is that correct?
Yes, that is true.
Okay. This is the pre-filed testimony of Mr. Cullen, and he states, this is page 14 of his pre-filed testimony, that according to ORS, the disallowed NND costs are about $1.8 billion. According to the company, the actual NND costs are $4.6 billion, and ORS's recommendation for allowed NND costs is $2.7 billion. Is that your understanding of what ORS's position is?
Yes, it is. If that is from the ORS testimony, ORS witness's testimony,
Which it is. What I'm putting up here is just a chart that shows those numbers we just went through. I'm just going to put that up there. So is it your understanding of ORS's optimal plan that they believe the company is not entitled legally to that $1.8 billion difference?
I believe that is the ORS's plan, although that would be a question to the ORS witness.
I just want to make sure I understand your understanding of their plan, because you have critiqued their plan and said it's not in customers' best interest, correct?
Yes.
And is it your understanding of ORS's position that SCE&G is not entitled to that $1.8 billion because ORS believes those costs were incurred imprudently?
It is my understanding that the ORS has a mandate which allows them to limit their view only to the NND, or that their interpretation is that they are able to limit their view only to one aspect of the company, which is the recovery of NND costs, without having a responsibility to review the overall financial health of the company. They have disavowed taking a concern in this proceeding in what the financial repercussions will be to the company's financial condition. And I find that very troubling because the company's financial health is an important resource for customers, for the economy of South Carolina, for the economic development of the service territory. And it is impossible, in my view, to look only at the NND cost recovery in isolation, leaving the company potentially in a distressed condition.
Thank you. Ms. Lapsom, this is Section 280K of the Baseload Review Act. Would you mind reading that highlighted language, please?
Recovery of capital costs and the utilities' cost of capital associated with them may be disallowed only to the extent that the failure by the utility to anticipate or avoid the allegedly imprudent costs or to minimize the magnitude of the costs was imprudent, considering the information available at the time.
Did you review the Baseload Review Act when preparing your testimony?
No, I did not.
Okay. Is it your understanding from the language that you just read that the Baseload Review Act does not allow the company to recover capital costs if they were imprudent?
Are you asking me for a legal interpretation of
I'm asking
the act?
you for your understanding of the language that you just read.
Well, I am not an attorney, and so I don't usually interpret that except in a financial aspect. So it seems to me that there is a limit there to the ability to recover costs, and that has to be balanced, in my financial view, has to be balanced against the need to maintain a viable and sustainable company.
Were you here yesterday when I cross-examined Mr. Addison?
No, I was not.
Would you accept that I asked him whether he thought the commission should hear all the evidence on costs and the prudency of costs and make their own decision about which costs were prudently incurred? Would you accept that I asked him that question?
I will accept that you asked it. I didn't hear you ask it.
Okay. Would you accept that he said the commission should make that determination?
Mr. Chairman, I would object. If he's going to try to ask the witness, trying to pit one witness's testimony, he can ask this lady about her opinions, how she arrived at her opinions, but now he's just trying to review the testimony of someone else.
Okay.
Sustained.
Thank you, Your Honor. Ms. Lapsom, do you think the commission should weigh all the evidence and make its own determination about which costs were prudently incurred and which costs were not imprudently incurred?
Yes, I believe that the commission should do so. I believe they can do so, but I also believe that they should consider the viability and sustainability of the company, not in isolation of one particular set of costs, but in terms, holistically, in terms of the integrity of the company as a result of whatever decision they reach.
So, Ms. Lapsom, am I understanding you properly that you think that if the company or the commission finds that the company incurred that $1.8 billion imprudently, there is a scenario in which you think the commission should still charge customers for part or for all or some of it because of other considerations?
My view is that from the view of the financial community, from the view of the ability to raise capital, and the ability to maintain a sustainable, solvent, and viable utility. And so I am not going to wear the same blinders of saying that a particular organ can be cut out and the cash flow associated with it can be cut out and leave the company without sufficient cash flow or without sufficient financial resources, and that is justified by an obligation to provide a particular determination. I think that the mandate, the ORS has a limited mandate, and I think that the Commission has a broader mandate.
Well, let me ask my question again. Let's say that the commissioners find as a matter of fact that the company incurred that $1.8 billion imprudently. In your opinion, that does not end their inquiry about the cost recovery of that $1.8 billion, does it?
As far as I'm concerned, I am not a legal expert. I'm not here to interpret the act, and I certainly would not seek to tell the commissioners how they should interpret the act or their obligation. But I am here as a financial expert, and I can answer questions about the financial viability and ongoing solvency and sustainability of the company.
Do you think that the Commission should be concerned with the ongoing financial stability of the company, even if it means making customers pay for imprudent costs?
I think that the commissioners do need to be concerned about the solvency, stability, viability, sustainability of the utility. The utility provides vital services to the population, to its customers, to economic development in the state of South Carolina, and I do believe that that is a valid concern and a very important one.
No further questions, Mr. Chairman.
Thank you. We're going to take 10 minutes and then we're going to finish.